In Malaysia, the Consumer Protection Act 1999, particularly after its 2010 amendment, plays a significant role in safeguarding consumers from unfair contract terms. These terms, often found in financial agreements, can create a significant imbalance in the rights and obligations of the parties involved to the detriment of consumers. With the rise of complex financial products and services, ensuring that contracts are fair and transparent has never been more important. Joining me today is Dr. Ong Tze Chin, the Senior Lecturer in the Faculty of Law, Universiti Malaya. I want to say thank you very much, Doctor. It's fantastic to have you here. Firstly, let's understand first, what is unfair contract terms and perhaps some case studies you can share with us?
Terms in the contract we have not been individual negotiated, so they have been significantly cause an imbalance to the parties' obligation, particularly the vulnerable parties here, which is the consumer. So we know that there is a lot of standard form contract in the market, particularly in financial industry. So all the terms in the contract is actually pre-drafted by the by the bank, by the financial institution, insurance companies and all this. So they are drafted with a legal jargon, with a legal expert there, which actually consumers are not able to comprehend their risks and also the obligation and what are their rights actually in the contract. Most often or not, we see this kind of contract is totally one-sided. It's only more advantage to the businesses or to the financial institution industry rather than there is protecting the consumer interests.
And what are the most common types of unfair terms found in financial agreements?
So unfair, as for example, there is a risk allocation. For example, consumer is to share the same risk as the bank, which as a consumer, we are not considered as an investor. Could we share the same risk with the bank? Or sometimes the exclusion clauses, for example, the bank can exclude all the liability, right? So all liability, for example, negligence for the bank, right? Without further information, and any rate changes will from time to time it change. And the calculation, they make it so complex, the calculation of the interest rate, so depends on the market fluctuation, particularly the legitimate interest of the consumer is not protected. Basically mean that the worst is the unilateral change of terms. It means that the financial institution or any industry can actually change the term when and where then they think fits for that issue. So that is particularly unfair, particularly to consumer, and consumer do not have enough information to actually determine what are their right choice and what are the risks they're actually sharing with this kind of agreement or loan agreement or mortgages or investment product or facility or services they are signing up with the businesses, particular financial institution.
And how do consumers typically become aware of these terms before or after signing a contract?
So it's an unfair contract that actually you have to take into account all circumstances. It means that pre-contractual information, during contractual information, and post-contractual information. These three are very important for consumers to determine, to actually assess their risk or what is their informed choices, whether to go to this a bank or this financial institution, this industry, this insurance facility or the other. So the most important thing actually for unfair term, we separate into two theoretical ideas, the concept which is procedural unfair and substantively unfair. Procedural unfair, it means the method into which you enter into the contract is unfair itself. For example, consumer have basically we don't have any bargaining power. So do you able to bargain with the particular industry or the financial institution to say that I do not agree with this term, can I change it? There's no right to bargain. They all standard form. Right? And another big issue is, so the procedure when before you enter into contract, they actually explain to you, because the contract is drafted in such a way that it's hard to understand and hard to read. So not just with all the legal jargons. So there's a lot of research. So there's research conducted particular since 2009, 2013, and 2020 by the US researcher. They say that some of the terms in the contract can range us to 74,000 words, right? which we agree so quickly before signing, and we do not know the significant particular exclusion of the liabilities. So basically, at now at current stage, the company or businesses, financial institution, or any industry, they can set whatever terms as they like, as good the basic liability, right? So for the good example case, we have a case in 2018, CIMB Bank, Berhad, and Anthony Lawrence Brook. So in this case, actually went to the federal court, and we was the first time we actually recognized that there is inequality bargaining of power, right? So basically, consumer, you don't have bargaining power, either take it or leave it. So in this case, the court actually said that there is a clause which is hindering consumer legitimate interest, which is they say that any negligence by the bank, they are not able to even claim, not even able to bring an action to a court. It means that they have hindering your basic right of access to justice. You cannot even sue the bank, right? So what is that? At the case, we have a very good judgment where the court recognized that there is an imbalance of equality or bargaining power, but that was not decided under Consumer Protection Act, but it's decided under Contract Act Section 29.
And we know the lengthy contract and many complex legal jargon, including the inequality for consumer to bargain, is one of the factors that many of the consumers individual might overlook. And we can say that is where a law or some legal action needs to be taken in place. And talking about the Consumer Protection Act 1999, can we check until now how effective it is in addressing unfair contract terms?
Actually, we have the law is quite good. Basically, under Consumer Protection Act 1999, Part 3A, Part 3 Capital A, we have actually criminalized it. We actually prohibit, in Malaysia, we are prohibited to have unfair contract terms. The significance is high, but there's problem about enforcement. And also, so can you rely on the consumer to actually bring a claim under the civil suit to understand what is unfair terms? Just like just now I explained, unfair terms have a both different concept of procedural and substantive unfairness. We cannot rely, and the burden of proof is beyond reasonable doubt, which is a criminal activity, right? So can you ask the consumer to know what is unfair or not unfair? So I would say it is a job of the what you call authorities to actually go through the unfair terms. And also we have a particular section in Consumer Protection Act 1999 actually provide the court to actually raise the issue of unfair term. But even those, that is a question, but seldom this have been raised in court. So particularly I mentioned the what you call the offences under Section 24I, capital I. So is contrary anything of the Part 3A, which is unfair term, to be an offence. For the corporate body, a fine are not exceeding 250,000, and the second subsequent offence is a fine not exceeding 500,000. That is an offence. For individual as well. So even individual can have unfair contract, right? We have a case in 2001, Saadat, right? So that Saadat and Mawi case. In that case, so there is a coconut farmer who do not understand English, enter into the contract. And of course, there's a question of undue influence. So in that case, with the first time, we recognize there's inequality bargaining of power. So basically it means that even there is negotiated contract can have unfair term as well. It means that they significantly affect the rights and obligation of the other parties. Because there is the vulnerable party who cannot understand the extent of the contract and what are the obligations and the rights there is. Then again, some contract even can have a term and saying that you cannot cancel the contract. Then it's subject to penalty or some default rules or default fees you're supposed to pay, right? That is clear cut. It is undermine the legitimate interest of the party who enter into a contract. Right? Even for individual, the fine are great. The fine is 100,000, even imprisonment of a term not exceeding 3 years or both. A second or subsequent offences to a fine not exceeding 250,000, and imprisonment for a term not exceeding 6 years or both. So there's basically unfair term in Malaysia is prohibited. But we still see so many unfair terms, particularly standard form contract is common. So it's not the law is not effective. We have all the law to protect us there. So the implementation, the authority with the particular resources to actually go through that, whether this term or this standard form contract are unfair and bring an action, right? So under the Consumer Protection Act, so we have the controller on assistant controller. I mean, for particular industry, because for any industry, the terms are standard form. So you go to one, for example, one bank to another or one insurance company to another, they are the same condition. So the another big issue is there is a competition issue, right? Again, this company and these businesses, they can standardize the condition, so which provide you with no choice. You go to one to the other is the same. So what do we choice we have, right? So basically, there is no choice, and there is competition issue. This is actually detrimental to the consumer or to normal, general public to actually went into a transaction, particular, I would say, a financial instrument or financial services which are of a higher risk.
And this is the reasons and factors that Malaysia need to regulate unfair contract terms. Are there any examples of countries with stronger regulations that Malaysia could emulate?
Actually, a unfair contractor have been existed a long time ago. So in UK, the unfair contractor is under the Unfair Contractor Act, so 1977. So Singapore as well and other common law jurisdiction, they all have unfair term. But I would say we are very serious because we criminalize it. To an extent, we actually already criminalize it, right? The problem is the implementation. So we are prohibiting this unfair contract term. Right, so and also the enforcement. So now it's only UK there is a amendment under their Consumer Rights Act as well as their Unfair Contract Term Acts, right? So they provide a duty, the specific duty to the court or to the tribunal to actually raise the issue of unfair contract term when there is a consumer dispute who arrive in the court. So basically, because like our system. So common law system is depends on the lawyers to raise the issue. What are the issues the court need to look at? So then the court will decide on the particular issue, right? So this often or not, this unfair term issue was not raised. So now they impose a duty to the court. We do have that similar section. The section is on basically there is a power granted by the court, right? Or the tribunal to raise the issue of unfair term, but there is not a what you call compulsory duty. It means that there is a power for the tribunal or the court to raise this unfair term issue for consumer contract.
And this is very insightful sharing on helping us understand from the consumer side. And thank you for walking us through the regulatory landscape in Malaysia, the necessity of these laws, and the real-life examples of unfair terms in practice. Again, I would say thank you very much to our guest, Dr. Ong Tze Chin, the Senior Lecturer in the Faculty of Law, Universiti Malaya.